The National Injury Insurance Scheme, or NIIS, is a state-based scheme which applies to persons who sustain serious personal injuries as a result of motor vehicle or workplace accidents. To date, the NIIS has been implemented in respect of motor vehicle accidents through the National Injury Insurance Scheme Queensland Act 2016, which also amended the Motor Accident Insurance Act 1994. The Workers' Compensation and Rehabilitation Act 2003 has also been amended to implement the NIIS in respect of workplace accidents. In the future, it is intended that the NIIS will also cover injuries relating to medical treatment and general public liability. While each of these pieces of legislation are intended to create a unified scheme, there may be some operational difficulties given that each of the acts has been designed without express reference to the others.
Under each of the state schemes, the NIS and the WCRA, there have been changes brought about with respect to entitlements for compensation that are quite profound. In terms of the NIS scheme applying as it does now to motor accidents, there is, for the first time, a broad no-fault scheme that allows a person with serious personal injuries to have the benefit of compensation payments to provide for their treatment, care and support, including for the period of their life. Under the WCRA, there always was, of course, a scheme by which a worker who suffered injuries, including relevantly here serious injuries, could receive compensation payments without proving fault. However, that scheme was limited in time and, generally speaking, was fixed to expire at the point in time when the person's injuries were assessed to be stable and stationary.
To be eligible under the NIIS, a person must have sustained an eligible serious personal injury as a result of a motor vehicle accident or workplace accident. Serious personal injuries include permanent spinal cord injuries, traumatic brain injuries, multiple or high-level amputations, severe burns, inhalation burns resulting in permanent respiratory impairment, and permanent blindness caused by trauma. Specific eligibility criteria for serious personal injuries is prescribed by regulations made under each of the National Injury Insurance Scheme Queensland Act 2016 and the Workers' Compensation and Rehabilitation Act 2003. Once accepted into the scheme, a participant may be able to receive any treatment, care and support needs that are necessary and reasonable in the circumstances. These may include medical or pharmaceutical treatment, dental treatment, rehabilitation, ambulance transportation, respite care, attendant care and support services, aids and appliances other than ordinary personal or household items, prostheses, education or vocational training, or home or transport modification.
The schemes, in terms of the way in which they operate and in terms of the way in which they regulate the provision of those benefits, including with respect to damages claims, are quite complex. It's not possible to descend into all of the detail of that complexity here, but some key features can be observed in this regard. Under both of our state-based schemes, contrasted to some of the interstate counterparts, common law claims are preserved with respect to the component of damages that are described as treatment, care and support. However, the way in which that preservation operates, variably across these two schemes but with some things in common, is quite novel in our jurisdiction. So by way of example, whilst a person may pursue a claim for general damages, for their pain and suffering and for their economic loss in the ordinary way, when it comes to treatment, care and support, they have to make a particular election to do so. When a person makes that election, the claim can of course be resolved by way of a settlement, but if it has to go on for an assessment of damages, once the judgment is published, there's a short period of time provided for the injured person to decide whether to accept those damages or not. And if the person decides not to accept the damages, then the insurer, or in the case of the NIS, the agency, is not obliged to pay those damages for the treatment, care and support, and the person remains eligible to receive treatment, care and support, including lifetime treatment, care and support compensation payments from the relevant payer. So it's in effect an opportunity for the injured person to test the waters and see how the assessment turns out before being bound to it. And so if there's an unfavourable outcome for whatever reason, then the person can elect for the comfort of certainty. The other matter that is relevant is that, generally speaking, a worker who has a damages payout that includes lifetime treatment, care and support by way of a settlement or a judgment against his employer, the insurer under the Workers' Compensation Rehabilitation Act, can, 5 years after the date of the settlement or the judgment, apply to the relevant insurer for a continuation of treatment, care and support benefits if it is to be said that, as it has turned out, the amount of the payment received in the damages for treatment, care and support was or has proven to be inadequate. A similar scheme applies with respect to the NIIS, where a person who is eligible for the NIS scheme has received a damages payment that has included treatment, care and support damages. How that will work in practice, only time will tell. It may be noted that in each instance, an acceptance back into the scheme may be conditional, and one might imagine that that could include the person paying to the authority some amount assessed as still being left over from their damages in return for acceptance back into the scheme on a lifetime basis. That sort of situation may well arise. With respect to the WCRA scheme, however, there is a question mark about how the 5-year rule will work, given that under the WCRA, by virtue of section 119, a person who has received a damages settlement from their employer for their injury is no longer eligible for compensation. In a sense, that seems to provide for a conflict between the provisions in the Act that allow for the person to come back after 5 years. How those provisions are to be reconciled, only time will tell.